Every now and then on this channel I receive a comment from a supporter of auditors telling me that auditors are not subject to data protection because they are individuals rather than organisations. A lot of auditors also seem to hold this belief themselves. This is categorically wrong. An individual who processes personal data for business purposes is subject to data protection just as much as a company or other type of organisation, and the individual will often be required to register as a data controller pursuant to Regulation 2 of the Data Protection Charges and Information Regulations 2018. In the case of auditors, if an auditor is running a monetised YouTube channel, then he is subject to data protection and must register as a data controller. Incidentally, the requirement to register as a data controller also applies to journalists, artists and photographers. The Special Purposes Exemption that they benefit from in Part 5 of Schedule 2 of the Data Protection Act 2018 does not provide them with an exemption from the requirement to register. Failure to register means a possible fine from the Information Commissioner's Office. Recently, one of my subscribers, who I won't name, emailed the Information Commissioner's Office on the following terms. I seek clarification as to whether there is a legal requirement for a monetised YouTube channel creator who films individuals on private property from a public location to register with the ICO as a data controller. The same clarification is requested whereby said person films from within a publicly accessible area of private or government department operated, example job centres, premises. If such a requirement is in force, then details of the legislation that covers such a requirement would be appreciated. I've actually answered all of this many times in my videos, and I've just answered it now. Here is a reply he received from the Information Commissioner's Office. I've redacted certain private information which I'm sure you'll understand. The reply includes a grammatical error. It says, with regard to content creators, they are deemed, I think that means deemed, to be an individual. The data protection legislation only applies to an organisation when it comes to the processing of personal data. So unless this individual is set up as a registered company, they would not need to comply with data protection legislation, and the issue you may be facing regarding the filming would be a civil matter for the police to advise further on. That reply is incorrect. It's incorrect throughout. As the ICO's own website confirms, in the FAQs on the ICO website, it states this about the requirement to register as a data controller. The fee is payable by a range of companies from sole traders and small to medium-sized enterprises, SMEs, through to large organisations depending on your practices. The amount payable varies depending on the size of the organisation. You can see there the reference to sole traders. An individual who is a content creator and earns money from a YouTube channel is a sole trader for business purposes. Therefore, an auditor who has a monetised YouTube channel is subject to data protection, including the requirement to register. The source of the confusion here on the part of the person who replied on behalf of the Information Commissioner's Office is in the use of the word companies, because it is being used loosely to mean any sort of business. We all probably realise that sole trader is not a company in legal terms, but for the purpose of trying to explain things in an accessible way, the ICO use the term companies in that sense. I've noticed that the ICO actually prefer to use the word organisation in most of the information they give out on their website and elsewhere. For example, this website page, which is a help page for small organisations, and you'll see on it that the ICO refer to small organisations as small to medium-sized enterprises, SMEs, small businesses, sole traders, small charities, groups and clubs and small startups. The point is that the ICO use the word organisation to cover any business purpose, including a sole trader. In dictionary terms, an organisation is either a body corporate such as a company or a group of individuals. A sole trader or partnership could be an organisation, but often it is not. Yet even a sole trader working alone is still subject to data protection if he is processing personal data. Unfortunately, this genuine attempt on the part of the ICO to make things easier for people to understand has led to confusion, and it appears duff information is being given out by the ICO. The person who sent out the incorrect email has obviously got confused and taken organisation to mean a registered company, which clearly can't be the case because an individual who is a sole trader could process personal data, as could a group of individuals who form a partnership such as a law firm or accountants. Many large businesses are not companies. By using the term organisation as a term of art, the ICO is opening the way for semantic confusion and inadvertent law breaking. What their advice and guidance should refer to is individuals and organisations, not just organisations, and that would clear up the confusion. I phoned the ICO about this, and the person I spoke to agreed completely with me that an individual can be subject to data protection as much as a business, and that for data protection purposes an individual who is in business is considered to be an organisation. I expect that despite this explanation, I will continue to receive comments from arrogant and stubborn individuals who refuse to accept that auditors are subject to data protection. Why they would take that position is anyone's guess. A large proportion of the people who support auditors are, frankly, a bit nutty, and that comes across in many of the comments I receive. It doesn't apply to all of them. Some have just been sucked in but are otherwise sensible people. The failure to adhere to data protection standards is at the root of the abusive culture of social media auditors. I suspect that in some cases, the misunderstanding about this amongst auditors is on purpose because it suits them to pretend that they aren't subject to these requirements, even though they know they are. However, the reply from the ICO does suggest a possibility that some auditors may have been relying on a genuine misunderstanding or misapprehension due to information being given out by the ICO, which I have to say is very disappointing to see from the ICO. What we see here is a problem caused by people who don't know what they're talking about, including, it appears, some people at the regulator. It causes confusion.